What if just one short vacation could cost you your green card? Thousands of U.S. green card holders are now facing intense scrutiny at airports, and some are being blocked from re-entering the country despite following the rules. What changed? The laws didn't, but the enforcement did. In this video, we'll break down 7 hidden traps in the new U.S. immigration crackdown and how even one mistake could destroy your status. Stay to the end. Number 1 is the most shocking, and it's affecting parents the most. Before we dive deeper, please take a moment to like this video, subscribe to Borderline America, and turn on the notification bell so you never miss important U.S. immigration updates and global living guides. Now let's break things down even further. Number 7. Frequent short trips are now a red flag. Let's start with the most unexpected twist. You might think that short vacations or quick family visits are harmless for green card holders. But under the new rules, too many short trips could now raise red flags faster than a single long absence. So what's really changed? U.S. Customs and Border Protection is no longer just looking at how long you were gone. They're now focusing on how often. They've started analyzing your travel patterns to figure out if you're still truly living in the U.S. It sounds subtle, but it's a major shift. Even trips under 30 days are being counted and questioned. In fact, multiple reports from immigration attorneys show that people who traveled abroad 4 or more times a year, even for short periods, have been flagged for interviews at the airport. Why are they doing this? Because under the new interpretation, it's all about intent to reside. Not just where you are on paper, but whether your lifestyle proves the U.S. is your real home. And here's where it gets risky. A person who's gone for 6 months straight to care for a parent may pass without issue, but someone taking monthly 2-week trips for work could be questioned because it looks like they're based somewhere else. The data backs it up. Since early 2024, at least 800 green card holders were referred to secondary inspection after multiple short trips. Some were issued notices to appear. Others had notes placed on their green card records, forcing deeper checks every time they return. That's the new reality, but not everyone agrees. Critics say this new approach unfairly targets business travelers, international caregivers, or anyone with family abroad. They argue that intent to live in the U.S. can't be judged by trip frequency alone. Immigration lawyers call it residency by algorithm, where travel data is treated like a red flag without context. Meanwhile, CBP says the new scrutiny is necessary to prevent green card misuse, especially by people who live overseas but still collect U.S. benefits. And trust me, wait till you see number 1, because it's not just about travel anymore. It's about how your taxes, job, and even your address could cost you your green card. Number 6, think having a re-entry permit keeps you safe? Think again. A growing number of green card holders are learning the hard way. Even with a valid permit, you can still be denied entry. Here's the reality. A re-entry permit used to be the golden ticket. It allowed green card holders to stay abroad for up to 2 years without losing their status. But under the new wave of enforcement, that protection is no longer guaranteed. CBP officers now have more discretion than ever, and if they believe you're using the permit to live overseas while keeping U.S. benefits, they can flag you, or worse, refer your case to immigration court. And this isn't just theory. Since mid-2024, immigration lawyers have reported over 300 cases where green card holders with valid re-entry permits were sent to secondary inspection, interrogated for hours, or issued a notice to appear in court. Some even had their permits questioned and revoked on the spot. What's changed? It's not the rules. It's the interpretation. CBP now views a re-entry permit as a request, not a guarantee. If your life appears based outside the U.S., if your home, job, or taxes point overseas, officers may decide you're no longer maintaining intent to reside. And that's the magic phrase again. It doesn't matter if your permit says 2 years. If they think you're not truly living in the U.S., they can take action. Many immigration experts warn this shift is deeply unfair. They argue the U.S. government can't offer a travel permit, then punish people for using it. One attorney said it's like handing someone a seatbelt, then arresting them for wearing it. But government officials defend the change, claiming too many people use the green card like a membership card, living abroad while keeping access to U.S. healthcare, taxes, and benefits. Under tighter border policies, that's no longer tolerated. And here's where it gets even tougher. For many green card holders, it's no longer about having the right documents. It's about proving your daily life is still rooted in America. That's what we'll break down. Number 5, so you've got your green card, you've got your re-entry permit, you even cleared the airport screening. But here's the problem. If you can't prove your U.S. life on paper, none of that may matter. What's the new rule? Under the updated enforcement, green card holders are now expected to carry solid physical proof that they still live in the U.S., not just visit. This isn't just about your address. It's about showing that your entire life is rooted here. We're talking utility bills, lease or mortgage documents, U.S. tax returns, employee letters, school enrollment for kids, bank accounts tied to a U.S. address. Even your driver's license is being checked for consistency. Why now? Customs and Border Protection officers have been instructed to treat re-entry like a mini residency audit. If you can't prove continuous ties, you may be sent to secondary inspection, sometimes for hours. In more serious cases, you might walk out of the airport with a notice to appear in immigration court. According to immigration data from 2024, at least 1,000 travelers faced these document checks, and over 200 were flagged for lack of proof. Real-world example. One permanent resident returned from a 5-week trip to help her daughter abroad. She carried her green card, passport, and re-entry permit, but she couldn't show a current lease or recent pay stub. She was detained, interrogated, and had her green card marked for future scrutiny. Her case is now in legal limbo, all because she didn't have a folder of paperwork proving her U.S. life. Civil rights groups call this practice proof-based profiling. They argue it creates a two-tier system where only the wealthy or hyper-prepared can travel freely. Critics also warn that it hurts older immigrants the most, especially retirees who may not have pay stubs but still live full-time in the U.S. But officials say the rules are necessary. They argue that fraud is growing and stronger documentation helps weed out fake residency claims. But here's what makes it worse. Even if your trip was an emergency, even if it was short, you could still be flagged. Number 4. Now this is where it gets heartbreaking. You'd think helping a sick parent or attending a funeral abroad would be understandable, but under the new rules, even genuine emergencies can trigger suspicion and possibly cost you your green card. Here's what's happening. Border officers are no longer just looking at why you left. They're looking at how it looks on paper. If your trip breaks the pattern of consistent U.S. residency, even for a valid reason, you could be flagged for intent to abandon residence. That's the legal phrase now driving these decisions, and it's being applied regardless of circumstances. Example. A green card holder flew to India to care for her dying father. She stayed for 4 months, then returned with medical documents and proof of return flights. Still, she was pulled into secondary inspection, questioned for hours, and told her travel raised concerns about her permanent residence intent. Her case is now pending review, and she's not alone. Since 2024, immigration lawyers report that emergency travel cases have tripled in legal consultations. At least 500 cases have involved people detained after caregiving trips abroad. Even more are receiving advisory warnings on their records, meaning extra scrutiny next time. Why is this happening? Because the system is moving away from intentions and toward patterns. CBP officers now judge your travel through a risk lens. Was the trip long? Does it fit a residency pattern? Is there proof of U.S. life during that time? If the answer isn't clear, they may assume the worst. Pushback from advocates. Critics say this new standard is inhumane. It punishes immigrants who are doing the right thing, caring for families, supporting loved ones, handling crises. Some say it creates a cruel choice. Be a good son or daughter, or protect your legal status. But government officials argue that leniency has been abused in the past. They claim too many people use family excuses as cover for living abroad permanently. So now they're enforcing the rules strictly and evenly. No exceptions. And if you think this only affects those who leave for months, think again. Because the next rule hits people who've never even left for long, but file taxes wrong. Number 3. This is the part no one tells you. You can follow every travel rule, stay under 6 months, even keep a home in the U.S. But if your tax records say otherwise, you could still lose your green card. Here's what changed. For years, immigration and tax enforcement operated in separate lanes. Now the IRS and immigration authorities are working together. If you don't file taxes as a U.S. resident, or if you claim foreign tax residency, that can be used as evidence that you've abandoned your intent to live in the United States. And under the new enforcement wave, that's a deal breaker. Real case. One man spent only 3 months abroad per year, but he filed as a non-resident to avoid double taxation. When applying for citizenship, that tax status was flagged. Not only was his application rejected, his green card was sent for review. In 2024, over 600 green card holders faced delays or denials in naturalization due to tax inconsistencies. Dozens were issued requests for evidence RFE, asking for tax filings, W-2s, and residency declarations. Some are now in immigration court just for how they filed their taxes. Why does this matter so much? Because taxes aren't just financial documents anymore. They're now treated as proof of intent. Where you say you live on a tax form can override what's printed on your green card. Even small mistakes like using a foreign address or forgetting to update residency status can raise red flags. And critics are sounding the alarm. Immigration attorneys warn that many tax preparers don't know how this affects green card status. They say thousands of lawful residents may be unknowingly setting themselves up for trouble just by trying to save on taxes. Some call it a trap built into the system. Meanwhile, government officials argue that paying taxes is a core obligation of U.S. residency, and ignoring that weakens the system. And yes, number one is still ahead, where we reveal how just one wrong move before your citizenship interview could wipe out years of effort and take away your chance to become American. Number two, this is where things get truly unpredictable. You could have all your documents in order, travel within the legal limits, but still, one border officer's personal judgment could put your green card at risk. Under the new enforcement approach, CBP officers are given broad discretion to decide if you still qualify as a lawful permanent resident. There's no exact formula, no guaranteed checklist. They're now trained to assess your intent to reside based on a subjective evaluation of your behavior, documents, and even how you answer questions. How does this play out? Two travelers, same travel timeline, same documentation. One gets waved through, the other gets pulled into secondary inspection, questioned, and handed a notice to appear in immigration court. It's not about breaking the law anymore. It's about how your case feels to the officer in front of you. And the numbers show the shift. In 2024 alone, over 1,000 green card holders reported unexpected secondary inspections. Many were not flagged by a system, but by an officer who simply felt something was off. Even people returning from 2-week trips were held in question, some for hours. Why is this so dangerous? Because there's no clear appeal in the moment. If the officer thinks you no longer live in the U.S., even if you technically do, they can refer your case for deeper review. And once flagged, future re-entries become harder. Your file is marked. Your freedom to travel becomes conditional. The burden of proof shifts entirely onto you. Immigration advocates warn this opens the door to bias and unequal treatment. They call it green card roulette, where too much power lies in the hands of individual agents without accountability. Some argue this disproportionately affects older immigrants, those with limited English, and people from targeted regions. On the other hand, DHS officials defend the approach, saying it gives officers flexibility to catch fraud and abuse. But for green card holders, that flexibility feels like walking through customs on eggshells. And that brings us to number one, the rule that's catching thousands off guard, even those who've never broken the law. Because it's not about where you've been, it's about what you do right before your citizenship interview. And if you think the green card rules are harsh, wait till you hear how one short trip can erase your chance to become a U.S. citizen. Number one, you've followed every rule. You've lived in the U.S. for years. You've paid taxes, kept your green card clean, and now you're finally ready to become a U.S. citizen. But then you take one short trip abroad before your naturalization interview, and suddenly everything falls apart. Here's the shocker. Under current rules, to qualify for naturalization, you must show continuous residence and physical presence in the U.S. But even a trip over 6 months or multiple short ones before your interview can be used to argue that you broke that continuity. And now officers are looking very closely at that final travel window, especially in the 6 to 12 months before your application. Real case, a green card holder flew to the Philippines for just over 6 months, helping settle a family inheritance. She returned, applied for citizenship, and passed her English and civics test. But the officer flagged her trip and said she had broken continuity of residence. Her case was denied. She now has to wait 4 more years before applying again. That's 4 years of lost time because of one trip. This is more common than you think. Immigration attorneys report a spike in these denials. In 2024, over 700 applicants were delayed, reset, or rejected due to travel-related violations, many involving trips taken within a year of the interview. Some had their green cards re-examined entirely. Why it's so risky? Because when officers suspect you didn't intend to make the U.S. your permanent home, they don't just deny the citizenship. They can initiate proceedings to challenge your green card itself. That's right. You don't just lose the application, you could lose everything. And the worst part, even if the trip was legal, even if it was necessary, if it raises doubt about your intent to reside, they can use it against you. Some applicants had no idea their final vacation could be the reason they were denied. Others didn't even realize they crossed the 6-month line. There's no forgiveness once the review starts. Critics say this rule is unforgiving. They argue it turns green card holders into prisoners of geography, scared to leave the country even for family or emergencies. One immigration lawyer put it simply, your travel history shouldn't erase your American dream. But USCIS says the rule is fair and that becoming a citizen should reflect clear, proven ties to U.S. life. So here's the bottom line. A single misstep, a trip too long, too close to your interview, or too frequent, can undo years of effort. Not because you broke the law, but because the interpretation of your behavior changed. And in this climate, that interpretation is often harsher, less forgiving, and ready to question your place in America.